Let's cut right to the bottom line. How much are retaliation lawsuits worth, and when should you pursue a case? These are important questions and they deserve honest answers. So let's get right to the intro. We are going to answer those questions in this video by exploring the topic from 3 different perspectives. Number 1, if you were fired in retaliation for doing something protected by law. 2, if you quit your job after experiencing retaliation. And 3, if you're still employed but you're currently experiencing retaliation. Before we jump into those topics, 3 quick things. 1, this video does not cover the legal definition of unlawful retaliation. It might surprise you, but not all retaliation is illegal. That is why I highly recommend you watch my video on that exact subject before you decide to contact a lawyer. Link is below in the description. 2, even though I'm a California lawyer, I made this video for everyone in the United States. If you're not in California, this video will give you an analytical framework to understand how the law approaches damages. And more importantly, it will raise questions in your mind that you need to get answered by a lawyer in your state. If you are in California, this video is not legal advice or a guarantee. It simply lists the basics on how damages work. To get an idea of how much your case might be worth, you need to call a lawyer in California. Here's my contact information if you think I'm worthy of that phone call. 3, each part of this video builds upon its previous parts, so don't skip ahead. Watch it all the way through. All right, if you were terminated or laid off for doing something protected by law, you can recover several different things. First of all is your lost wages, and you can recover your past and future lost wages. Number 2 is your pain and suffering. This is emotional distress. 3 is punitive damages. 4th is sometimes attorney's fees. And 5th is the very, very important intangible things. Let's tackle your lost wages first. Lawyers call these economic damages. And these damages look at your past lost earnings and your future lost earnings. The best way to explain this is using an example with a nice round numbers. So let's assume that at your job you are making $100,000 a year. Then the company retaliates against you unlawfully and fires you. Well, you're not making $100,000 a year anymore. Now, let's say you find a new job exactly 1 year later making $50,000 a year. 2 years to the day after you were fired, your case goes to trial and you win. How much will you get? Well, let's examine the past first, then we'll go to future. Year 1, it's pretty simple, right? You were making 100, you're not making anything because you're unemployed, that's $100,000. Year 2, though, there's a differential between your new salary of $50,000 and what you were earning of 100, so there's a differential of 50. If you add those 2 up, it's $150,000. But that is not the end. You would also get your future lost wages, and your lawyer will hire an economist who will run all sorts of fancy calculations and will come up with a future projection as to what you would have earned had you not been unlawfully fired. For simplicity's sake, let's assume that your economist puts together a projection that calculates that each year at your new job you'll get a $10,000 raise. So 5 years from now, since you're earning 50, you'll be back to where you were before you were fired, making 100. But let's look at the differentials. Year 3, you're making 60. Differential between 100 is $40,000. Year 4, the differential is 30. Year 5, the differential is 20. Year 6, the differential is 10. And year 7, you're back to earning $100,000. The total, if you add those up, is $100,000 in future economic damages. So you add your past economic damages with your future economic damages, and your total economic damage picture is $250,000. Obviously, this is an oversimplified example, but it should give you an idea on how economic damages, i.e. lost wages, work in retaliation lawsuits. Next, we look at pain and suffering. Pain and suffering damages are awarded to employees who receive significant emotional distress injuries as a result of being the victim of unlawful retaliation. Emotional distress injuries are not something that you can make up or fake. People try and they usually fail because you're going to be evaluated by experts who testify all the time in front of a jury. But seriously, how do you put a dollar value on hurt feelings and emotions? Well, it's difficult to do, but we hire experts who testify as to the person's change in behavior. Was their identity wrapped up in their job? Did the person seek professional psychological help? And we build a case and we present that case to the jury, and the jury decides how much money you get or how much you don't get. In serious cases, these emotional distress damages can be many times larger than the person's lost wages. Next, let's talk about punitive damages. Everybody has heard about punitive damages. These are the damages meant to punish the bad company, to deter it and other companies from behaving that way in the future. Punitive damages are very hard to win. You have a much higher burden. You have to show that the company acted with malice, oppression, or fraud. This is much more difficult to do than most people realize. Everyone thinks that their case is worthy of punitive damages, but statistically that's just not true. In my estimate, I would say in less than 10% of employment cases that go to verdict are punitive damages even seriously considered. However, if you do win them, they can be large because the Supreme Court has set an upper limit of 9 times your underlying compensatory award. What do I mean by that? Well, let's say you won $250,000 in lost wages, and you also won $750,000 in pain and suffering, for a total of $1 million. Punitive damages, according to this upper limit, could be as much as 9 times that award. So, in theory, you could win $9 million on top of a $1 million compensatory award. How often does that happen? Very rarely. It depends on many factors, which I'm not going to get into here. But at the end of the day, in retaliation cases, punitive damages are a very real thing. Next, let's talk about attorney's fees. In some areas of employment law, if you pursue a retaliation case all the way to trial and you win, the law allows the employee to recover attorney fees on top of the other types of damages. If your case does have this ability, it increases the leverage that you have in settlement negotiations. Why? Because if you go to trial and you win, but you only win a small amount, say like $30,000, that's a small verdict. But the company will still be on the hook to pay your lawyer. That could be 7 figures, even though it's based on a small $30,000 verdict. There are several published cases in California where an employee won small, but the company still had to pay a small fortune. So obviously, with that hanging over the company's head, it increases the settlement value for you, the employee. Next are the very important intangible things. This is all about leverage. Obviously, the more leverage that you have, the more money you will get. This section covers the intangible points of leverage that can dramatically increase the value of your case. Number 1 are the facts. This revolves around what actually happened to you. How bad is the retaliation? When presented to a jury, is the jury going to be furious with the company, or are they going to think that you're a big exaggerator? I had a case several years ago where my client had a dog leash wrapped around her neck at work. She had plastic bags put over her head. Obviously, those are abhorrent facts that any jury in any circumstance would find terrible. And that was excellent leverage that I was able to use for my client's benefit. That case settled fast and for a lot of money. Next, honesty. Are you an honest person? Did you tell the truth to your lawyer? Did you tell the truth during your deposition? Does the company tell the truth? If one side lies, it increases the other side's leverage. Every single time one of my clients has lied to me or under oath, it has dramatically decreased the value of their case. So please, just tell the truth. Next is media coverage. Everybody thinks this is a huge deal. It's usually not. It's rare. But it can increase the value of your case if it has local applicability and the local news cares about it. But usually it's not a factor. Next is temperament. What is the temperament of the person signing the check? Is it an emotionally charged business owner who would rather sink his company than settle a lawsuit? Or is it a rational business owner who makes a prudent business decision? And your temperament is also very important. I'll give you a good example. I have a good lawyer friend of mine who does the same area of law. He was negotiating a settlement for an employment client, and he negotiated a settlement value of in excess of $1 million. But the client was stubborn and wanted more. My friend advised him to take the settlement, but he refused. They ended up going to trial and losing. That was $1 million mistake. Next, insurance. Is there an insurance policy that covers your claim? If so, what are the policy limits? What is the insurance adjuster like? All of these are extremely important factors. Finally, your attorney. How good is your lawyer? How good is the company's lawyer? Believe it or not, but this has a huge effect on the value of your case. Aside from the facts of the case, the single largest variable that contributes to getting a good settlement or not is the quality of your lawyer. So choose wisely. Now, everything we've talked about so far presumes that you were fired. Well, what happens if you quit? Generally, if you quit after being retaliated against, you can still file a lawsuit, but there's one very big problem. Unless you can establish that your termination qualifies as a constructive termination, you cannot collect your economic damages, your lost wages. The law establishes that if you voluntarily quit your job, you are not entitled to recover lost wages in your lawsuit. Okay, well, what exactly is a constructive termination? According to California law, a constructive termination is when, due to the employee having a legally protected characteristic or engaging in a legally protected activity, the employer makes the working conditions so intolerable that a reasonable person in the employee's position would have had no reasonable alternative except to resign. Now, let me be honest, it's very hard to win a constructive termination claim. Judges hate them. As a result, it's hard for people who quit their job to find a really good lawyer to pursue their case. Now, I've taken constructive termination cases in the past, but I'm very picky, and I have good reason to be. If I'm going to invest thousands of dollars of my own money and hundreds of hours of my valuable time into a case, I need to be confident that I'm going to recover enough money to make it worthwhile for my client and for my firm. You're probably asking yourself, well, that's economic damages, but what about the other types of damages, Branigan? Yes, even if you quit, you can still recover pain and suffering damages, punitive damages, and in some cases, your attorney fees. But unless extraordinary circumstances exist, it's usually a losing strategy. Why? Because lost wages are measurable and easily understood and accepted by judges, juries, experts, and the opposing lawyers. Alone, pain and suffering damages are not. They are very touchy-feely, and punitive damages are rare and considered speculative at best. In my opinion, lost wages are the key that unlocks those other types of damages. So, is it worthwhile to file a retaliation lawsuit if you quit your job? The answer is maybe. Remember that example I talked about my client having dog leashes wrapped around her neck and plastic bags put over her head? She quit her job, and she got a very good settlement. So in certain situations, there is a very good reason to file a constructive termination claim. Real quick interruption before we get to the last part of this video. If you're finding this video to be helpful and informative, please give it a thumbs up and subscribe to my YouTube channel. If you know somebody who's going through retaliation right now at work, share this video with them. They will thank you for it. Okay, let's get back to the good stuff. All right, we covered the situation if you were fired and the situation if you quit. But what if you're still employed and you're experiencing retaliation at work? Well, if you're still employed, you're still earning your salary, your commissions, or your hourly wages. So unless you are denied a significant raise or your pay was cut significantly, you haven't lost a lot of money yet. This situation is very similar to the constructive termination scenario we discussed just a few minutes ago. This makes it hard to pursue a lawsuit if you are still employed. Now, there are always exceptions to this, but generally, If you are still working at your company, lawyers like me tell folks two things. Number one, complain about the unlawful retaliation in writing. If you are going to complain, I highly recommend that you watch my video on how to make the correct type of complaint. It's very important that you do that properly. I'll put a link below. Number two, we also tell people to call us back if they're fired. You're probably thinking, well, call you back when I get fired. That's too late, my job's gone. I understand. This brings me to an incredibly important point about the legal system. The tools that the law has given employment lawyers like me generally are not effective at stopping bad behavior at your work or preventing retaliation from continuing. We are far more effective at pursuing justice after the fact. Why is this? Well, it's pretty easy. People are emotional creatures, and lawsuits are like throwing gasoline on a fire. If you sue your company while you are still there, not only is this going to be very uncomfortable for you, but you will paint a big target on your back. Nobody is going to want to see you succeed. The company will want you to fail. They will watch you with a microscope and document every perceived failure. So is it worthwhile to file a retaliation lawsuit if you are working at the company? Generally, we recommend waiting until you are fired to pursue a case. But there are always exceptions to the rule, so if extraordinary circumstances apply to you, don't be afraid to call a lawyer for a consultation. I hope you found this video to be helpful. If you are in California and you are experiencing retaliation, don't be afraid to reach out to my office for a free consultation. All right, that's all I have for you. I hope you have a fantastic day.